Good evening. So it gives me tremendous pleasure to be able to begin this evening's conversations with lawyer Michael Sfard, with whom Forensic Architecture, in conjunction with CT Research based in New York, we have worked very closely together in particular in relationship to several legal cases within the context of the Israeli occupation of Palestine. Those are, of course, highlighted in the exhibition here at HaKever, and I will just remind you of those three cases: the death of Bassam abou, the use of white phosphorus as ammunition within the urban environment, and the landscape of Batir versus the State of Israel. In terms of a brief introduction, in terms of how this conversation is going to unfold, I think it's important to understand that the term forum that is embedded within the title of both the project and the title of the exhibition, although it is very much oriented towards opening up new spaces of public engagement, new spaces of public kind of discourse, I think it's become very apparent in the tour, for those of you who have, or the tour that you might have participated in, or the works that you've seen, the significance that we place on engaging with the law, and in particular, the spaces in which the law is operative and performs its legal set of operations. So by intervening and engaging with the law, of course, we in forensic architecture, we're not merely referring to the law in terms of its constitutive capacity to adjudicate wrongs, assess legal claims, and pass judgment, but also the kind of unmasking or engaging with the ways in which the law itself is deeply implicated in the production of human rights violations through its legal judgments that produce or expand the conditions of harm and oppression, through rulings that adversely affect certain people and situations over others. So, in effect, the ways in which the law is both used and abused. Now, our conversation today is going to be structured by a series of key points that we're going to make through the specific examples of the legal work undertaken by Michael Sfard and his colleagues at Bassam, Yeshdin, and Yeshkvul with the Forensic Architecture Project and with C2. And in each case, we'll try to unpack the ways in which strategies and work produced by FA both enables certain new legal conditions, but perhaps also brings to light certain new problems. What we're going to try and manage in this time frame is to analyze a certain kind of shift from testimony to kind of materially inscribed kind of witnessing. We will try and look at the ways in which different conceptions of truth operate very differently in different kinds of forums. So the kind of public forum the forum of public opinion, legal forums, certainly political forums related to kind of diplomacy and domestic politics. Another thing that we will try and signal is the emergence of negative proof or negative evidence and the kind of political and moral impact this might have on human rights work. Also very significantly, the relationship between artists and lawyers who, traditionally we might say they inhabit rather antagonistic kind of realms, but what are the ways in which creativity might actually provide new kind of legal tools, perhaps the capacity to imagine and project kind of alternate future scenarios. And finally, looking at the ways in which the law itself is a tool that is implicated in the production of human rights violations. So with those kind of markers in place, I'd like to turn immediately to Michael and ask you, through your collaborations with Forensic Architecture, you've told me that the work that we've done together has been enormously kind of useful for you. Can you tell us why?
Well, good afternoon to all of you. It is important to understand the environment in which a human rights lawyer, a human rights activist is operating in the Israeli-Palestinian conflict context. when I first met the forensic architecture people and was offered help in one of my cases, it was after I grew to understand that growingly the traditional evidence that is used in human rights work is growingly become worthless. The basic brickstone of the work of every lawyer, but mainly of human rights attorneys, is the subjective testimony, the testimony of the victim, the eyewitness, the narrative of a person who tells his or her story. Now, politically, human rights work is not only using the personal story just to prove what has happened at a certain place in a certain time, but also to empower the victim so that the victim could tell his or her story, and by that at least be heard. Now, in an environment where there are massive human rights abuses on a daily basis, and especially when it is in the context of conflict, like it is in Israel-Palestine, the account of the private person, of the individual, becomes less and less trustworthy. Courts in Israel, the law enforcement agencies are much less willing to engage in legal prosecution and investigations based solely on the fact that a Palestinian alleged that an Israeli member of the security forces or an Israeli civilian has committed a wrong. The individual account, the testimony, has become extremely suspicious because you know the traits of the human mind are such that people don't always remember exactly what happened, and there are false memories, and also a person has the capability of lying, which is something that seemingly objects and documents can't. So growingly, the testimony of the victim and the eyewitnesses that viewed the event have become less and less something to work with for lawyers. It was replaced first by the still photograph. The still photograph that held the aura of being the ultimate truth. It recorded reality as it was. The judge can see by himself, be in the scene of the event. But that also growingly has become suspicious and not trustworthy, as we understand that the still photo has a frame, has a border, that it records something that is very limited in space and in time, what happened before the picture was taken, what happened after the picture was taken. And then we also learned in recent years that behind the camera there is, again, a person, a human being, and the human being is again attributing these subjective elements to the picture, and suddenly even the still photo, when we went to police stations and showed photographs of an event, would become, well, you know, we don't know what happened before, what happened after, this is not really a proof to anything. The still photo was then replaced by the holy grail that is called the video footage. The video footage is definitely an ultimate proof of what happened. We have a time frame that is recorded. We can, if the camera moves, we can see what is left of the still photo, what is right of the still photo, and video is actually the new basic evidence that is asked. It reached such a point that we were going to police stations and alleging complaints that something happened, and the policeman in the police station immediately asked, "Where's the video?" The worst case was the case of the sister of Bassam Abu Rahme, which we'll talk about in a moment, Jawahir Abu Rahme. The Abu Rahme family lives in Bilin, a small village in the West Bank that was campaigning against the construction of the separation fence that was built on their land, taking away more than 50% of their farmlands. This village was protesting every week on Fridays, and during those protests, people were injured, and Jawahir was killed. She has been suffocated from tear gas, an enormous amount of tear gas that was shot on the village that day. And when the story broke out and the media became obsessed with it, a demonstrator, non-violent demonstrator that was killed in the demonstration, the IDF spokesperson has made the comment to the press, we have scanned all the videos. Jawahar was not in the demonstration. She died from cancer somewhere else. Just because none of the videos that were taken during that demonstration captured her. So that became this sort of negative proof. If you're not captured in the video, that means you're not there. And then came the case of Bassam Abu Rahme, which was the ultimate case for, to use this holy grail of video evidence. Bassam, Jawahar's brother, whom I knew personally because I was litigating the case of the Village Council of Bil'in against the separation fence, and I've been there many times, and he was one of the activists in the popular committee of the village that was running, or one of the organizers of the demonstrations. And in a demonstration that was extremely small, of course non-violent, of course unarmed, he was shot, and he was, a gas canister hit his chest, and he died on the spot. This event was documented not by one video camera, not by two video cameras, but by 3 different video cameras from 3 different angles. You can't have a more documented event than that. Well, that's what one would think. When we've brought these videos to the law enforcement agencies, they looked at them and said, we can't know from the videos who shot, why, and in what angle, and their preliminary inquiry, they reached the conclusion that a soldier probably shot according to the regulations up in the air, and that the canister hit the upper wire of the separation fence, changed course tragically, and hit Bassam. I called it back then cartoon physics. So that's when our forensic architecture arrived, and maybe we'll show something from the report that has been done by forensic architecture. These are the 3 videos. Maybe we'll show first the videos. These are the 3 videos put together of the event.
Let me just to go to the, sorry. Where's my video?
No, yeah.
Yeah, here we go.
Okay. You'll see Bassam in yellow shirt. This is the separation fence that you can see. That's him yelling. He yells, there's an Israeli injured guy, stop shooting, he yells. That's him falling. Now, the video, the actual moment that Bassam was hit was captured in one of the cameras, but you don't have one video that shows both the culprit and the victim. So the question was, how can you attribute the specific shot to one of the 7 or 8 soldiers that we saw standing there? What you can see in the big picture here is actually when the forensic architecture experts have analyzed frame by frame, they found one frame. Maybe we have the bigger.
This is the biggest.
That's the biggest. Okay. So what you can see in the big frame, they found the one frame that recorded the root of the canister. And after that was found, then they could reconstruct digitally the scene and understand and prove exactly which one of the soldiers was the one that shot and was able to bring about this root. Also, they have proved that actually the shot was done in parallel to the ground, meaning in direct aim at Bassam. So when we brought this to court, because the Israeli army has refused to launch a criminal investigation into this event, claiming that, as I said before, the shot was aimed according to regulations, but tragically the canister hit the fence and changed course. This report by Forensic Architecture has actually compelled the army to retract his position, being afraid of losing in court, and they have indeed launched an investigation they didn't want to launch in the beginning. So what we have here is this evolution from the eyewitness account, and you know, there were 10, 12 people here, not including the soldiers. They could all give a testimony, but that's like nothing. That doesn't count. That's not objective. That's not neutral. So the still photo is also not like that. The one video doesn't help. Then suddenly we have a new holy grail. We have the experts of forensic architecture or any kind of forensics, which take the lead in being with the aura of being neutral, objective, and finding the ultimate truth. Of course, a word of warning: this is collaborating with this idea that people testimony, eyewitnesses, the victim testimony is not worth much, and that, of course, as I said before, from the political point of view of human rights work, is very problematic.
Yes, I wanted to actually ask you these two questions. First is we understand the potential contribution that forensic architecture had made in this case, and you talked about two things that came out of that: the notion of a new form of expertise that was located within a collective, and the ways in which the law has yet to understand expertise that isn't allocated in a single individual who can speak on behalf of their particular kind of knowledge, and also the ways in which it provided you with a certain kind of leverage.
That's right.
And in some way, I think it's very important for us to also kind of elaborate a certain cautionary note that you're signaling here. What is we can see a certain kind of advantages in this kind of shift to increasing sort of scientific, seemingly objective accounts of events, but as you've said, the over-reliance in the case of the IDF or the police, who are actually, if there's no video camera present, there's effectively nothing happened. And how forensic architecture's work might actually be implicated in that transition in a way that is problematic. So,
well, the novelty, at least again in the environment where I work, the novelty of having a group of experts that does things that are not that the government cannot counter, definitely not in the time frame that we have, is really very significant, because traditionally the government has almost monopoly on forensic evidence. They have their ballistic experts and pathological experts and all kinds of experts, and the NGO community, the civil society, has much less recourse to such state-of-the-art technology. Forensic architecture has enabled us to be first in bringing a new frontier of forensics, which the state was not ready to. Now, I guess that knowing how states are, how governments are, I guess that while we're sitting here and talking, there are departments of forensic architecture being erected in governmental offices, and in no time the governments will have, because they have more resources and more power, they will use these kind of techniques to counter our work. So this is we will always have to be one step ahead. We will always have to be creative and to find new ways to prove things, ones that will put the government, in this case, in surprise, and they will have, as happened in this case, you know, when they got the report, they didn't know who to give it to, how to react to this. The danger that the court will accept this as a real expert opinion that has weight, that proves something, was enormous for them. So in that sense, I think it was the right thing in the right time, but we have to acknowledge that with time, governments are very adaptive and will be able to counter that.
And what about you talked about leverage, but also the ways in which when you arrive in court, the court in some ways already primed to the event precisely because it started to circulate in all kinds of other kind of forums in the press, in the media, and that you understand the work that we're doing is also through its circulations, perhaps in non-kind of legal forums, can also play a kind of crucial role in potentially shaping the ways in which the court is going to receive, like its receptivity to a particular legal petition.
Absolutely. I mean, in other cases that I've been working with forensic architecture, the purpose of the work was not to bring necessarily evidence to court, but to create some kind of visualization of things that otherwise the judges are not aware of or cannot know, or the public opinion. Now here I have to say there are different standards of proof when you go to different forums. There is one, the type of proof, or the standard of proof you need to convince the public through the media is one. The type of proof that you need, or the standard of proof you need for politics is another. And in court you have all different standards. There is the criminal standard of beyond reasonable doubt, there is the civil standard that is much lower. And so depending on what you need, you can adjust to that. Now, these forums influence each other. So if we have a case in which the work of visualization and creating a model that will allow people to understand better what has happened, create some kind of atmosphere in the public forum, that in turn will influence the law. That will influence the court forum. And I have again, example from Bilin. Bilin, the petition we filed against the construction of the separation fence in Bilin, which eventually we won, and this fence that you see here was ruled as illegal by the Israeli High Court of Justice. It took 4 years and 2 contempt of court motions to have the fence removed, but nevertheless we won. When we got to court, it was one of 80 cases that challenged 80 different segments of the wall. So Bilin was one segment out of more than 80. But the first question that I was asked on the podium by the then Chief Justice of the Israeli Supreme Court was, tell me, Mr. Sfard, what is so unique about this case? Why are they demonstrating every week? So that gave me the signal that, the type of public work that we do, the fact that the village itself is engaged in massive protest and demonstrations, the fact that the media is involved in it and we have all kinds of tools to create interest, is feeding back into the court. And then I get a court the way I want it, el dente, it's ready to help us. So this is the kind, and maybe we can show the case of Batir, in which the Batir case is a case where another segment of the separation a fence or wall or apartheid wall or separation barrier, depending on your view regarding that project. The village of Batir is a very ancient village. It has 4,000-year-old terraces where agriculture is being carried out the way it was in biblical times. It is going to be declared as a World Heritage Site by UNESCO. It got many prizes, and the only reason that it is like that is because for 4,000 years, uninterruptedly, the villagers there could cultivate their land. It's very unique. There is a spring of water that is carried out by aqueduct to the different terraces, and 8 big families are distributing the water among themselves. Each family has one day that it can drive the water through the aqueduct to their plots. That's why the people of Batir say that in Batir we don't have 7 days a week, but 8 days a week. So anyway, the State of Israel has decided to build the separation fence through the lands of Batir, cutting this unbelievably ancient place into 2, but also destroying many of the terraces. And in order, and I'm involved in this case on behalf of an Palestinian, Israeli, Jordanian environmental organization. And in order to, now this part of the fence is not yet built. So the judges have to imagine how it will look like when it happens. What the wizards of forensic evidence have forensic architecture have done for us is to help us visualize how the area would look like when the fence is already erected, because the question of what would be the degree of damage was crucial for the case. Now here you can see an image that was created to try to show the court, but not only the court. This was printed in Israeli newspapers, and there were documentaries, news reports on that. And also, the forensic architecture has also created a video that visualizes how it would look like to drive through the area where the fence is. There is a train track there, and that way one can not just imagine, but actually see how it looks like. So you have the fence on your left, which is not there today, and you have this huge, very broad road that would have destroyed 2 or 3 terraces. And you can see that the other side you can actually understand that the side that is beyond the fence, on the so-called Israeli side or west side of the separation fence, would be completely sealed for the people of Batir. The interesting thing here is that when we have filed these tools of visualization with the court, the army has decided to counter it with its own type of visualization. And it was done, I don't know if you have it, but it was done in a very, I don't like the word primitive, but very, well, not sophisticated way. But you can see how in their visualization, the angle in which they portray the fence is from high up, and the fence looks very small and not so intrusive and not so bad. So this is not really evidence. It is evidence only in the sense that it helps the public, the decision makers, and then the judges to make a decision. And actually, I have to say that this case is still pending, and I have to say that the judges have, I think, have really understood how intrusive, how damaging this fence would be, in many ways, thanks to this kind of visualization.
I mean, you said something very interesting to me, extremely provocative, and I think it's very fascinating for us here, because I suspect there's also a lot of people here who might be engaged in contemporary art practices, and the idea that art itself could provide you with new legal tools. And in some way we see an example of this through the production of visualizations that actually are kind of projective. They are not evidence of or an account of an event that took place, but they propose a kind of image which you can then actually, which is quite operative and can be instrumentalized by you as a kind of legal tool. And I think it's incredibly significant to imagine the ways in which artists and their modes of visualization, their kinds of practices and analytical methods might actually offer new legal tools.
Well, I hope this is a new love story between art and law. These are two disciplines that seemingly are not just far away from each other, but almost one the opposite of the other. Law is about, again, I'm referring to very shallow concepts, but law is about truth, about facts, about neutrality, about objectivity, while art is about creativity and imagination and subjectivity. So how can these two converge? Lawyers, on the one hand, I think feel inferiority towards artists and people of pen and paint. And maybe their way to deal with this psychological problem is by pushing away artists from their discipline, saying, well, you're good for maybe entertainment, but not for the real stuff, to make judgments. I think that some of the work of forensic architecture has proven that art can feed very well into law. And it is doing so by a very peculiar way, one in which we return back to the question of the narrative of the victim or eyewitness, of the person, of the human being. One of the works of forensic architecture is the work on drone strike in Afghanistan, and you have documented an interview with a survivor who is working together with a sketch artist who is showing trying according to the imagination, not to the memory of the individual, of the survivor, to reconstruct the scene of the drone strike. And what you see in that video is amazing. You see that through art, she regains her memory. I mean, it's not, it's one thing to bring a survivor to court and to ask, okay, tell us what happened. Now, it was 2 years ago. She was traumatized. Everything is blurry. And, well, actually, her memory is not that good. It's a completely different matter to have her sit with an artist and have a process and document that process. Then you regain the evidentiary worthiness of her memory, because it's not like the memory was there and it just froze in time and now she spits it out, and we should ask ourselves, is her memory accurate? Does she lie? We can actually see, this is why it's so important that the interview and the whole work with the artist was documented, was videoed. We can see the process by which memory regains its strength and becomes more and more vivid, and thus, in legal terms, becomes of weight. And I think that in that sense, although still the art has to be constrained, the artist, like here in the footage, the imaginary footage of the fence in Batir, hopefully it will stay imaginary because hopefully it will not be constructed, but the artist has a lot of leeway, has discretion, how the sky would look like, what would be the light, and so on. But the artist is constrained by certain elements, like what is the height of the fence, how dense are the wires, and so on. So I think we can see in this work two, so to speak, different directions. One that belittles the worthiness of human accounts, while the other strengthens it and provides it back with the respect that we need.
Shall we look at the white phosphorus case?
Okay, the what? Yeah.
And perhaps I'll begin by playing the short animation.
Sure.
And maybe there's no sense of, maybe it makes sense for you to speak over it.
Okay, this is a picture taken in Gaza during Cast-led attack, where ammunition that contains the substance of white phosphorus, which is a substance that when it comes when it exposes to oxygen, starts burning. was deployed on a UN structure in Gaza. Now, we have still photos that show this, and then forensic architecture has provided a visualization through a digital model of the structure, and so we could see the stills in the context of how it actually looked like, where and in what area it was deployed. The problem with the white phosphorus case, in which an Israeli NGO through my office has tried to get a court order against the Israeli Defense Forces to insert a command that would prohibit the use of munitions that contain white phosphorus in urban areas. The problem was that the law was not very clear in the sense that it was subject to interpretation. International law regarding incendiary weapons is very clear that it is not allowed to use incendiary weapons in urban areas. However, the definition of incendiary weapon was one that was interpreted by the Israeli army as a weapon that is intended to be used in order to burn areas. So the intention of the guy who presses the button decides what is the classification of the weapon. We have argued that the definition of incendiary weapon is about not intentions but results. If a weapon causes significant burning of areas and it is an area weapon, then it should be classified as incendiary weapon. Now, in order to combat the interpretation of the army, what we needed is something that will explain the judges the implications of that weapon when it is deployed in urban areas. And here, I actually asked forensic architecture to do a stunt. And the stunt was, as you can see here, this is their work on you can see the elliptic white line that shows the area where that is affected by such munition in Gaza. And on the right, you can see the list of civilian objects that have been affected by it. The problem was that we wanted in this campaign to affect public opinion. And to be honest, public opinion when it comes to Gaza is very harsh in Israel. So what I asked forensic architecture was to create a model that will enable me to fire this munition in New York, in Paris, and in my hometown of Tel Aviv. And now you can see when we move to New York City, for example, what would have happened if the same munition in the same day with the same climate, with the same wind force, if that would be deployed on New York. Israelis go more often to New York than to Gaza. And the same with Paris and, of course, Tel Aviv. And that was, I'm calling it a stunt because it was almost a PR tool. It was, the idea was to help people better understand what it means to use this weapon. This case I consider as a very successful one because at the end, again, we had a case in which the army would not go all the way and wait for a judgment of the court, but it has indeed inserted the prohibition on use of white phosphorus munitions in urban areas, barring two very narrow exceptions. But here we can see how these kind of new techniques can help in both generating public opinion and visualize and try to help judges and lawyers understand what it means.
And Michael, perhaps in the minutes that we have left, I think it would be also useful to talk a little bit about, the panel is titled Anarchists Against the Law, and we could talk somewhat about kind of legal strategies of perhaps legal rupture, but also the ways in which the law itself is used and
Abused.
more often than not abused.
Well, the term anarchists against the law was a term that I used furiously in one of the panels that I've participated in the Hebrew University in Jerusalem after the Cast-led attack on Gaza. During Cast-led, the Israeli army has used lethal force and mainly airstrikes on the most populated area in the world, Gaza, and most densely populated. And it targeted objects that are clearly civilian, like governmental ministries. Actually, the attack on Gaza began with a bombardment of a Palestinian police ceremony, and the police is considered to be civilian. What has unfolded was that the military lawyers have actually provided a very creative interpretation of the laws of war, including the most important principle of the law of war, which is the principle of distinction. The principle of distinction says that there are two statuses, one of combatants and one of civilians, and combatants may never target civilians, and only combatants and military objects are legitimate targets. One of the reported legal advices that the Military Justice Corps has provided the army was that the police, for example, in the attack of the police ceremony, the police, although it is civilian, in times of war, they have combat role. And so in times of war, they become combatants and so are legitimate targets. But as I said, the attack on the police ceremony was the first attack of the Cast-led operation. So there was no war when the attack occurred. The legal advice was that once the attack happens, when the missile is being launched, there is war. So actually, when we shoot the missile, this missile is a pretty wise missile. It changes the status of these policemen from civilians to combatants, thus making them a legitimate target. And that is an example of how law that is supposed to be a order that would protect.
That was not the case. That is not true.
Well,
That is not true. What case was that it was said that the attack came from an area of civilians from Gaza.
No.
You are just lying to the audience here. The problem is that many attacks came from civilians until today.
That is true.
Distinguish between where the attack is coming from.
Okay, thank you. Thank you for the comment. It is true, not in this case. In this case, there was no allegation that there was a firing from the area where the police was holding its seminar ceremony. That was not. It's true that in many cases the argument is that we return fire to where fire comes at us. I didn't talk about these cases. This is more complex. What I'm talking about is the first attack in Cast-led, and it was not a retribution to an attack that came from that area. So anyway, the type of legal interpretation that is shown in this case and other cases was such that actually made law a vehicle to abuse rights. Instead of law being a shield from arbitrary and unjustified violation of rights of individuals, it became a way to legitimize a human rights abuse. And why legitimize? Because the law has an aura that provides the party that can claim that he's operating under the law or according to the law, it has legitimization force. And So, you know, this is why I called the International Law Department of the Justice Corps of the Israeli Defense Forces anarchists, because actually they have completely destroyed the legal order that they're supposed to defend.
On that note, I think we have to wrap up. That's the end of our conversation. I would like to, first of all, thank you, Michael, both thank you and all of the colleagues, many of whom I've met, and the work that they do, and also the kind of their interest and generosity in working with forensic architecture and seeing what we might actually produce together as a new set of legal conditions in the fight for justice. And I would also like to extend my thanks to Hakaveh and all of the team and people who have been tremendously supportive in enabling both this event to take place and the presentation of our research material. So thank you very much.